Thank you very much, and thank you to all of you who came to this hearing. I know it's a long day, and it had a hard start with all the details of the Magnitsky case. For us in the Helsinki Committee, the Magnitsky case became important because it showed all elements, I think, of the problem that we are dealing with today. Even in all versions of the case, you can see that there was a massive economic crime as the start of the case. And then you can discuss who did what. But there was massive tax fraud. Nobody denies that. And then there was human rights violations connected to that tax fraud. Even if you take the, let's say, the weakest version of what happened with Magnitsky in the prison, he shouldn't have been there, for once. And he was dying in the prison. He started as a healthy man, and then he died. So clearly something went wrong. And what went wrong had something to do with human rights. And then the case was not investigated. That's why we have this big debate about what happened. So there you also have human rights issues. And then the third element is exactly the question from Brynjulf, what happened to the money? And I think for us, this is maybe one of the most important part of this story, because the money came to us in the Western countries in one way or another. And it has to do with our systems not being ready to fight all this whitewashing, as we call it in Norwegian, money laundering. So this has been an eye-opener for the Norwegian Helsinki Committee as a human rights organization, because the problem was we had some years with progress on democracy and human rights in former Soviet countries, in Eastern Europe, in other parts of the world. But let's say a decade ago, this progress stopped, and we even had setbacks. And of course, our main task is to report on human rights violations, but sometimes we have to ask ourselves, why is this bigger picture happening? Why is the progress evaporating just before our eyes? And maybe you know from, you remember from the election campaign for Bill Clinton, it's the money, stupid. And we were a little bit unaware that the money is actually the key issue here, because so many human rights violations happens because of money. So if I can, yeah, it's working. I think this is the problems we are facing. States fail to protect the rights of whistleblowers and human rights defenders, as has been shown also by Pavel Chiko's presentation. Sometimes they even go after the whistleblower instead of protecting the whistleblowers and going after the criminals. And states do not implement decisions by international human rights bodies in a way that address the reasons for human rights violations, the systemic violations of human rights. Even if there is a court decision in Strasbourg by the Human Rights Court, the only thing many states do is to pay compensation. But then the same violation reoccurs time and time again. And this has to do with the individual human rights violators not being made accountable. This is what we call the impunity problem, which is extremely widespread. And for human rights organizations, which always is in favor of strengthening international bodies, like in the Council of Europe and the UN, we also have to admit that only a fraction of the cases come to these institutions. So there is the tip of the iceberg, and there is a lot under the surface. As has been mentioned earlier today, there has been a breakthrough in the UN. Third Committee of the General Assembly. There is a very nice text adopted by consensus, meaning that China, Russia, Venezuela, Saudi Arabia, they are fine with this resolution, but we have to ask us, why are they fine with this resolution when you have all these problems in these countries? Because I think they have no intention of implementing it. Of course, we will work hard, and we think it's important with these resolutions, but we have to do more. This is the most respected human rights institution in the world, I would say. But the court decisions by the Human Rights Court in Strasbourg are only halfway implemented in some of the member countries. In some of the Chechen cases, there are even names of responsible persons, but nothing happens with those names. This is undermining the European human rights system. I think later today we will hear about other moves which is undermining the Council of Europe, which has to do with corruption. I think this was made in 2015. It's the headquarters of the UN in New York. And Norway is also always supporting the UN to be the place to solve the problems of the world. And we will continue doing that. But we think that the UN resolutions, they need more teeth. And Magnitsky sanctions is among those teeth. So we don't say the Magnitsky sanctions will solve everything, but we think that that will back up what is coming from the international institutions, and it's needed. So this is what happened on Monday this week. UN member states, by consensus, endorsed the free and independent role of human rights defenders. And the Norwegian foreign minister said that the international community has sent a strong signal. Human rights defenders have a key role to play in strengthening respect for human rights all around the world. And that is important, but we think it's not enough. And here is why. Because corruption and other forms of international or economic crimes lead to a lot of human rights abuses. And we think that the money involved is such a barrier for solving these problems that there are need for more hard measures. This I have from Transparency. Over 2/3 of the 166 countries and territories in the 2016 index fall below the midpoint of the scale. In an easy word, we could say they are more corrupt than clean. And the global average is also below the midpoint, indicating endemic corruption in a country's public sector. And as illustrated by the Magnitsky case, but also by many other cases, human rights violations is the twin brother of corruption. And again, we want the UN to be strong. And there is a very interesting and very good corruption convention with a far-reaching approach, and the mandatory character of many of its provisions make it a unique tool for developing a comprehensive response to a global problem. The convention has 183 parties. Among them are many of the most corrupt countries in the world. Here is the picture, the blue ones. They have officially stated that they have an obligation to fight corruption according to the provisions of the UN Convention, including Russia, China, Azerbaijan, etc., etc. Big part of the problem is that money laundering is too easy. And I must underline that the Human Rights Organization is not the expert on these issues, but we have to learn something about it, and I think we have to work together with journalists and lawyers and Transparency and other organizations to increase the understanding in the public in Western countries how this corrupt money is coming to us and undermining our system. There is an estimate, I have it from the UN source, that money laundering annually rates between $800 billion and 2,000 billions. And there is an estimate in the UK that only in UK annually money laundering amounts to 100 billion pounds. It's so much money I cannot really understand it. So this is what we learned from the Magnitsky case. Corruption in authoritarian states, corruption-related human rights violations, attacks on human rights defenders and others who are performing whistleblower or watchdog functions, and corrupt officials go free and they place the money from the economic crimes in Western countries. So this is what we call the heart of the problem. Financial gains from wrongdoing are threatened only by the exposure provided by human rights reporting and whistleblowing. And the officials who conduct the crimes may already control the police and the judiciary, which is also illustrated by the Magnitsky case. Independent media, human rights defenders and whistleblowers therefore constitute the only threat to their sovereign position above the law. Indeed, exposure of widespread corruption may undermine the legitimacy of an authoritarian regime to such an extent that it fears losing power. This may, to a large extent, explain the worsening climate for independent human rights reporting in many authoritarian states. So this could be one of the remedies. Magnitsky sanctions against foreign individuals or entities who are responsible for or acted as an agent for someone responsible for extrajudicial killings, torture, or other gross violations of international recognized human rights, or government officials or senior associates of government officials complicit in acts of significant corruption. And this is what is commonly understood to constitute gross violations of human rights, including torture and killing and politically motivated rape. It's important to understand that Magnitsky sanctions don't target states. It's individuals, affecting only those who have been documented, well documented, to have committed these crimes. Focusing on senior officials, those with a trusted position in the state, low-level officials, and their non-government agents or partners. In this way, they do not harm innocent persons by limiting the overall capacity of the state or the economy to produce welfare for its citizens. Assets freeze allows the seizure of any of the property held by listed persons in the country, including freezing bank accounts. And it also involves restricting the listed person's ability to open bank accounts, effectively preventing the person from entering into transactions with large numbers of banks and companies. And as a consequence of the US Global Magnitsky Act, both American firms and international firms with American subsidiaries run the risk of violating US sanctions if they do business with sanctioned people. So this is quite far-reaching. The other measure is visa ban. Sanctioned persons will not receive a visa, and if they have a valid visa, they will have that visa revoked. And sanctioned persons will not be allowed to enter a territory of the state, even if he or she is a citizen of a state with a visa-free agreement. So they are blocked. They cannot enter the territory of the state in any case. Conclusion. In our view, Magnitsky sanctions are effective because they target precisely those officials and their partners that are involved in large-scale economic crimes and who are attacking those who make efforts to expose their crimes. They defend the rights of human rights defenders. In this way, they supplement efforts in the UN, the Council of Europe, and other international organizations to uphold the rights to promote and defend human rights. And importantly, they are not against or for any state. Magnitsky sanctions are not anti-Russian. They are simply a tool to help protect watchdogs and whistleblowers and to make criminals accountable. That's it. Thank you.
Thank you very much, Gunnar. We are now rearranging the scene a little bit. We will have a small panel, a two-person panel, and what we want to do now is, before we break for lunch, we will have some evidence of the situation in 2 other countries, and to get more insight in that, and as a background for the discussion after lunch concerning more the need to improve and strengthen the protection of whistleblowers and human rights defenders. So, if Simon Papashvili is here, please, thank you very much. And you, Williamson, has he also arrived? Which I think is a question. He's on the way from the airport. Okay, so it's an even smaller panel then. Okay, Simon.
I think he's going to make before I finish.
Okay, we'll see. We'll see. Okay, but anyway, we are very happy that you are here, Simon, and to provide us with more basic information about the problem that we are discussing and the issues that are pertaining to many different countries. And your country of issue here is Azerbaijan. And we have asked you to prepare a presentation on this issue, and we will follow up with some questions. So we start with your presentation. So the floor is yours, Simon. Please give us
Thank you.
Share with the insight with us.
Thank you very much. Just to clarify, I'm not from Azerbaijan, I'm from Georgia. But Azerbaijan is a country on which I have been working for over last 10 years. I would like to start by saying that I'm extremely proud to make my small contribution to this very important campaign called Magnitsky campaign, which I believe is the most effective and successful campaign we have seen over the last 2 decades. This is more or less that I have been in human rights business, so to say. It is really inspiring to see how things are moving, and I believe this is just the beginning of a very important change that we are going to witness, and hopefully Norway will be the next one to follow the lead. The problem we, human rights organizations and the civil society community, often have is the setup under which we operate. And the setup we operate under is that we document human rights violations, and in some cases we help victims to access justice in their countries. We help them take cases to the courts, etc. But very often we are faced with a failure. So domestic justice systems in countries like Azerbaijan, Russia, etc., they simply do not work in most of the cases which are the worst. So what do we do in this kind of cases? We go elsewhere, and this elsewhere is international institutions like UN treaty bodies, like the European Court of Human Rights, which have been set up to safeguard certain fundamental freedoms in those countries which have signed on those treaties. But again and again we see that these international instruments, they don't work. And they don't work especially in those countries where human rights violations are worst of all. So the problem also from the civil society perspective is that sometimes we simply over-rely too much on those institutions which have a very limited impact. And we invest a lot of our time and energy in something which brings so little or no result. And I, as a person who has been doing this work legally and non-legally, I often ask myself a question: what can I do to make difference? What else can I do? I have been, for the last 8 years, based in Brussels and working on advocacy with the European institutions. And what I have seen over and over is how the European institutions fail to promote human rights in countries where they are most at risk. And now I'm going to focus on one case, which is the case of Azerbaijan. Probably most of you do know what Azerbaijan is and where it is, but just to, for some of you who might not know, Azerbaijan is a former Soviet republic, which is situated between Black and Caspian Seas, like my home country, Georgia. From the south, there is Iran, this is Armenia, and this is Turkey, and from the north, it is Russia. Azerbaijan is a country which has some similarities with Norway, and this similarity is in the fact that Azerbaijan is rich in oil and gas, which constitutes major source of income for the state. It's a public commodity, obviously, which is extracted by the state and by state-owned companies with the support of foreign investors and foreign companies, including Norwegian Statoil. This extracted oil and gas then is sold to other countries, like Georgia, Turkey, and is brought to Europe. But the problem is that proceeds from this sale of oil and gas, from this public commodity, big part of these proceeds are kept by a ruling elite which runs the country. And who are this ruling elite? The country, Azerbaijan, has been run by one family. It's family of Aliyevs. It's Heydar and Ilham Aliyev. Heydar Aliyev was a former KGB general who has had a number of senior positions both in Azerbaijan and in Moscow, as when Moscow was the capital of the Soviet Union. And then he became a president of Azerbaijan after the Soviet Union collapsed in 1993. He has passed away in 2003, and ever since his son Heydar Aliyev has been in charge of the government. And the way the family runs the country has very little to do with international standards, including those standards that Azerbaijan signed when it ratified some of the human rights conventions. So what are the major human rights problems? Number one problem is that the country has no free elections. Elections have been routinely falsified over these 2.5 decades since the Aliyev has been in charge. Aliyevs have been in charge. The violations do not simply happen on the election day, but there is no competitive election environment for opposition parties, opposition political figures to campaign. So Azerbaijani people have no possibility to express their political will through the elections. So the problem starts there. Second problem is, and it's related to the first one, is politically motivated imprisonment. What the Azerbaijani authorities do, they arrest everyone who dares to speak out and who dares to challenge injustice, who dares to speak out election fraud. And we have a colleague from Azerbaijan who heads Anar Mammadli, former political prisoners, and he can testify it himself. He was put in jail because he wrote critical reports about how Azerbaijan conducts elections in the country. So it's actually a country which has highest per capita in the Council of Europe political prisoners. A lot of attention has been given to this issue, but still there are more than 100 political prisoners in jail as we speak now in Azerbaijan. Very often when people are sent behind bars, they are subjected to torture and ill treatment. I'm going to speak about one particular case a bit later on, but this case is not the only one. We hear over and over reports by outspoken individuals who are imprisoned that they have been subjected to ill treatment and torture. Yet another problem is restrictive NGO legislation. Since 2009, Azerbaijani authorities have enacted a number of laws which make it impossible for critical voices, for critical human rights groups to have an organization registered or to receive any support from outside, financial or otherwise. And most of the leading figures in Azerbaijani civil society community have been either put in jail or forced to leave the country. So there is no space whatsoever for independent critical voices to do their work openly and engage in this important endeavor. Yet another problem is absence of independent media. Like with the civil society, what the Azerbaijani authorities have done, they have shut down all the independent media outlets. They have forced out independent journalists from the country. They have imprisoned independent journalists like Khadija Ismailova, who is still under travel ban. And they have also taken offline those media outlets who moved online when they were taken, like radio stations that were shut down or TV stations that were shut down. They switched to internet version of news, but their websites have been blocked. So they are not able to even deliver news, critical news to the Azerbaijani population via internet. Last but not least is the country does not have an independent judiciary. In Azerbaijan, judiciary is a simple extension of a repressive apparatus of the government and used to justify politically motivated imprisonment. And Azerbaijan is not the exception. There are other countries from the former Soviet Union bloc, but it has a staggering 99% conviction rate in criminal cases, which is very telling, of course. The case I would like to focus on is a case of Ilgar Mamedov. And this man, young man still, is in jail and has been in jail since 2013. He is a pro-democracy, anti-corruption activist turned politician. He leads Real movement, which is one of the opposition political parties in Azerbaijan. He has been put in jail in 2013 because he there was a massive protest in Azerbaijani town of Ismail, and he went there to monitor what was going on. Authorities put him in jail and accused him of organizing mass riots. Ever he has been in jail, he has been exposed to pressure in various forms. And one of the things he did after having failed to obtain justice in Azerbaijan was to go to the European Court. He went to the European Court, and the European Court in a record time for the average delivered a judgment on his case roughly 5 months after the case was filed on the reasonability of his detention under Article 5 of the European Convention. And this was an unprecedented judgment which was delivered by the court in the way that it was the first case when European Court practically recognized person as a political prisoner. Having found violation of Article 18 in conjunction with Article 5 of the Convention. Article 18 is a clause of the convention which limits derogation of rights other than those listed in the convention. Finding the violation, the European Court said that Mr. Mammadov has been imprisoned simply for making information critical to the government public, and that was the sole reason of his persecution. That judgment was delivered on the 22nd of May 2014, which is more than 3 years ago, and Mr. Mammadov is still in jail. While in prison, Mr. Mammadov is exposed to constant threats which come from the prison administration. He lives in a rather poor prison conditions which lead to deterioration, gradual deterioration of his health, which is then combined to the lack of medical care. He does receive some medical care, but it's far from corresponding gravity of his health condition. And he has also been on numerous occasions exposed to physical and verbal abuse. And one of those episodes was in 2015, on October 16, when he was taken into the office of the prison governor and beaten cruelly by a number of prison guards, and told that he has to sign pardon request that will be sent to the president. Obviously, he has launched a number of complaints to obtain justice. All of those complaints went without any result, any outcome. So what options Mr. Mammadov has to seek justice and accountability? I mean, he has been to the European courts, he has been to national courts. Actually, there are 2 judgments now in his case by the European Court. One of them was delivered last week, and last Thursday actually. And that judgment was judgment on the substance of the case, where the European Court found that Article 6 of the Convention has been violated. And Article 6, for some of you that don't know Convention, is right to fair trial. So we have a problem here. We have exhausted all the remedies inside the country, outside the country. We all know that the person sits in jail because of the political grounds, and there is not much we can do. When we go to the European Union institutions, including the European Parliament, they barely go beyond expressing deep concerns. An expression of a deep concern when you have an individual who has been put in jail and tortured for many years is not an adequate response. We need something else. And this something else, there are different ways to address this issue. But one of the ways which has been proposed is actually Magnitsky legislation. And as Gunnar just before me explained very clearly, this approach targets the very heart of the problem. In Norway, as a country which is a democratic state, which takes leadership in promoting rule of law and democracy globally in different fora, is one of those countries that we, civil society, rely on to pass such legislation that we can then use to expose and challenge the perpetrators and to seek justice. Thank you.
Thank you very much. It's very important to get this perspective from also other countries than Russia. And unfortunately, Mr. Wilhelmsen has not arrived yet, and some travel arrangements have been unkind to him. So we will soon break for lunch. I just wanted to ask you some question, because you work, I didn't mention that, you work as project director in the International Partnership for Human Rights, and you live outside the actual country. How are your possibilities to get reliable information about the situation of prisoners like this? which I think will be a basis for
Yes.
imposing sanctions.
We as an organization, and I'm speaking now on behalf of the International Partnership for Human Rights, for which I work, and it's an organization based in Brussels. We don't have any field offices except for Ukraine. The way we work is we rely on information that is provided by our partners. So we rely on local human rights organizations, local activists and lawyers with whom we work and whom we support. Sometimes we do go into the countries ourselves and do fact-finding and documentation work, especially when there are high risks for the locals to engage in such work. We have done this in different countries, including in Azerbaijan, including in Russia, where we have observed more than 40 court hearings concerning foreign agents' laws and how they were used against Russian organizations. Some of them are in this room, representatives of those organizations. So we do have ways to get our hands onto objectively verifiable information and data that then we use in our advocacy process.
Okay, and that which will be important, of course. But then we see Magnitsky laws are different than other sanction laws, and we say that that is a necessary move in order to address these problems, rather than other type of sanctions, which are more general sanctions on countries.
That's a very good question, actually. So, why do we need national laws as opposed to, for example, sanctions that can be adopted in the EU framework? The answer to this question is not very straightforward because it's a rather complex problem. I think we need both. The problem with the EU sanctions is that in order for the EU to adopt sanctions, it's the Council of the European Union which makes decisions anonymously, meaning all the member states who get together, they have to anonymously agree to adopt sanctions. And if one of the member states who might have whatever exposure to a country which is under question has high stakes at risks, then they will most probably veto this down, and we have seen it over and over, including in the case of Azerbaijan. We have campaigned for imposing targeted travel bans and asset freezes on Azerbaijan officials in the EU framework, in the European Union framework, but so far we have not been successful. If we work with individual countries, like Norway or other countries which already have such laws, including Lithuania, Estonia, United Kingdom, and Canada, and the United States, of course, then chances that we can get to concrete results are rather higher, I would say.
Please, Brynjar, and do you have some final questions?
I see that Hugh has also arrived.
Okay, I think yeah, the organizers say that we'll break for lunch anyway. Yeah. So we'll just finish this and break for lunch. Brynjar, do you have a final question for Simon?
If you could draw a little from what was said in the former panel, some of the discussion should probably be analyzed as a question of, is there a rule of law for those who are included in this Magnitsky list, for example? Do you have any views on that? How should the process be sort of organized in order to have sort of rule of law safeguards when people are included in the lists?
Thank you for your question. This is indeed really important question that countries who adopt Magnitsky laws have to ask themselves and answer. Any decision, I think, on putting people under sanctions list through the domestic legislation has to be done through a court procedure whereby a victim or a group of victims files a complaint, or their legal representatives files a complaint, makes a prima facie case of violation, meaning that makes a case that actions of whoever individuals have led to gross violations of his or her right. This person should be able to go, based on this legislation, to the national authorities, file complaint, be it prosecutor's office or Ministry of Justice or whoever it can be, and then this complaint should be investigated in accordance to due process standards, and I believe for the sake of impartiality, the decision should be made by an independent court. And those people who are subject to those sanctions should have a right to appeal.
Yeah.
Yes, I just wonder if you can elaborate on the corruption risks and problems in the country. I mean, you described lack of access to information, the lack of transparency, the limited space of civil society. So I'm just wondering if there are other measures that can be put in place to sort of crack on this problem. You said that the Magnitsky legislation could target, the heart of the problem. That's one. Would be nice if you can elaborate on that, but also to see kind of other measures that can be put in place.
Yeah. Corruption, I mean, going back to the Azerbaijan case, corruption is a huge problem in this country. And it's a problem which has left the borders of the country and went into places such as Strasbourg, where Azerbaijani government has managed successfully to bribe members of the Parliamentary Assembly of the Council of Europe. There are already ongoing criminal proceedings in a number of the Council of Europe states against members or former members of the Parliamentary Assembly who have been implicated in this scheme. And probably you have seen Laundromat on Azerbaijan. The OCCRP investigation has shown that more than almost $3 billion have been used as a part of lobby scheme by the Azerbaijani authorities to corrupt European politicians, including high-level European politicians. $3 billion, it's a lot of money. So what could be done and what we should be doing, we should expose this kind of corrupt links. We should expose those European politicians who dare to sell themselves to the kleptocratic regime of Azerbaijan, which violates human rights. We should also work with the media to raise the awareness in different European countries from where these people come from, so we need to shame them. And by exposing them, by shaming them, we hopefully will prevent such violations. One of the things we did and successfully managed to do was in the Council of Europe framework was the creation of a special external investigative mechanism which was set up by the Parliamentary Assembly, which is composed of 3 judges, one from the UK, one from Sweden and one from France, who are looking into these corruption allegations. And our hope is that on the one hand, the outcome of this investigation will be that more people who have been implicated in this corrupt scheme will be exposed, and then national governments will follow up by investigating criminal proceedings against those members of the parliament. But also we hope that the Council of Europe will enact safeguards which will prevent similar things from happening in this really important institution which has been created for exactly promoting human rights and rule of law in the member states.
Okay, thank you very much. I think we will continue this discussion after lunch. Mr. Williamson will be given some time to present his case just when we come back after lunch. So we'll break now.